This is the lecture for week 3 in the Law and Bioethics course at the Alden March Bioethics Institute. The lecture will be divided into 2 sections. First, I will talk about the 3 large questions related to medicine the law has historically been designed to ask. And then I will talk about malpractice and the standard of care, which is the subject that is addressed in most of the readings for the week. So first, the law has historically been designed to answer 3 questions. First, what is the practice of medicine, and what are the boundaries to the practice of medicine? Secondly, what should doctors be allowed to do? And third, how are doctors distinct from lay people? And I should add, even though historically these questions apply to doctors, and I'm talking about doctors in this course because I am a physician, you could easily apply these same questions to psychotherapists, to nurses, to individuals providing healthcare in a wide range of settings. The licensing of doctors dates back to the early 19th century. Before that, anybody with an apprenticeship and a desire to practice medicine could hang up a shingle. But starting in New York in 1806 with the Medical Practices Act, doctors were regulated. And the goal of licensing in the early 19th century in New York was to suppress empiricists, meaning people who actually used evidence in medicine in favor of people who had a holistic theory that they then applied to practice. There was also an effort to suppress homeopaths, people who believed that small amounts of substances diluted in water could treat disease, versus allopaths or allopathic physicians, which are the people for the most part practicing today, although osteopathic physicians also do practice today. It's worth noting that the licensing of doctors stopped in New York in 1844 and then restarted again later in the century. In fact, numerous states passed licensing laws in the early 19th century and then repealed them by mid-century, so that by 1850 there were only 3 states with licensing laws: Louisiana, Michigan, and New Jersey. The result of which was a very large number of quote-unquote physicians, many of them poorly trained, actually the largest percentage in the world. By 1860, the United States had a physician for every 571 people. It's also worth pointing out that in the early 19th century, it's not very clear that allopathic physicians were any more effective than homeopaths or laypeople. Largely, the 3 major advances of antebellum medicine were citrus for scurvy, iodine for goiters, and inoculation for smallpox. So it's not even clear that in the 19th century, if you saw a doctor, you ended up better off than if you didn't see a doctor. And there's some data to suggest that it wasn't until the early 19 teens that your outcomes were more likely to be positive than negative. In fact, Leroy Dutoil of the French Academy of Sciences published a study on cancer patients in 1843 that showed a correlation between mortality and medical care. Therapies included anesthesia without sterilization, caustics, heavy metals, quicklime, potassium permanganate. It is worth noting that medical error and iatrogenic causes are still a major cause of medical death in the United States. Some estimates are that iatrogenic deaths are the 5th or 6th leading cause of death in the United States. Iatrogenic meaning being caused by physicians. So that is worth thinking about as we progress into the physician-patient relationship and talk about malpractice. What everyone thinks of the American Medical Association, which more recently has become a very conservative organization that has pushed against public funding of healthcare, Medicare, Medicaid, national healthcare during the 20th century. In the 19th century, it served the very useful purpose of supporting regulations upon doctors, and it's one of the reasons why much of the regulation of doctors still today comes from boards that are composed of physicians and guidelines proposed by different medical associations, including the AMA itself, which is the leading source of ethics providers today in terms of regulation and codes. So one question to think about is, what exactly is the practice of medicine? Or rather, what are the boundaries between medicine and non-medicine? And the beauty box case was the first major case in the United States to address this question. Edna Hicks was a cosmetologist, a beautician in Arkansas, and in 1976 she decided to expand her business into ear piercing. Today, ear piercing is conducted widely by tattoo artists, by cosmetologists, by individuals who set up carts at the mall. But this was not the case in 1976. And surgeons petitioned the Arkansas State Medical Board, which declared ear piercing the practice of surgery and forbid her from practicing. You should ask yourself, is ear piercing the practice of medicine? And today it is not considered that in any state to my knowledge. Why does this matter? Because the unauthorized practice of medicine is a felony in many states. It's a Class E felony in New York State, for example, where I am located, which means you risk 4 years in prison, as well as the possibility of serving additional time for assault or reckless endangerment. So you really want to know whether or not you're practicing medicine in advance if you're not a physician. But if ear piercing is not the practice of medicine, what about tongue splitting or tongue forking? A practice where one cuts apart the two pieces of the tongue in order to allow for the cosmetic look visible on the slide. There's some risk of bleeding, there's some risk of pain, so you might want to have a physician do this. On the other hand, if you require a physician, very few physicians, if any, will agree to do this, and the cost will go up substantially. This was not the practice of medicine in New York in the 1970s when the beauty box case occurred. It is today as a result of legislative action. Which leads to the broader point that the definition of the practice of medicine can change substantially over time. For example, electrolysis, the practice of the removal of unwanted hair, as depicted in the slide here, historically was not the practice of medicine, but there's been increasing pressure from dermatologists to declare it such, which will expand their practices at the expense of lay electrolysis workers. You should ask yourself why this is any more or any less the practice of medicine, for example, than injecting Botox, which probably has the same level of risk involved and probably the same level of training, and yet it's clearly a dermatological practice. And the same could be applied to a number of laser therapies. I'm not endorsing one view or the other, just saying that historical practices often date or determine what is within the scope of medicine and what is outside the scope of medicine as much as any rational philosophical argument does. Delivering babies is an example of something that some people very strongly believe is the practice of medicine and others very strongly believe that it is not. Historically, prior to the 19th century, delivering babies was very much not the practice of medicine. It was the practice of midwives, the majority of whom were female. But over time, as women began delivering babies in hospitals rather than in the home setting, as surgery became available, as C-sections became more common, the medical community defined it as the practice of medicine and largely took over the business, and midwives, while they still worked, had to work under the supervision of doctors. Then, in the last 20 years, we've seen a significant reversal, and a number of states, including New York now, have redefined delivering babies, at least in part, as the practice of midwifery, a non-medical field, with its own set of rules, practices, and training. And now midwives in New York can practice on their own without medical supervision by a physician. Ongoing conflicts exist over whether tattoo removal falls under the scope of tattooing artists or should be the scope of dermatologists. Whether psychotherapy is something that only psychiatrists or trained healthcare professionals should be able to do, or whether it's something that a layperson with some rudimentary training, such as a lay analyst, should be able to do. I mentioned Botox injections, the question about whether or not you need a physician, and then whether or not you need a dermatologist, or whether, for example, your ophthalmologist or your psychiatrist should be able to engage in training and offer dermatological procedures on the side. There was a case in Louisiana a number of years ago where an ophthalmologist tried to perform abortions in her community because there were no local abortion providers, and the question was whether or not she was able to act outside her scope of practice in that way. The prescribing of herbal or traditional remedies, which is licensed in some states and not others. And then historically, a battle over the fitting of eyeglasses, whether it was ophthalmology or optometry. One general principle is that the practice of medicine involves offering treatment to specific individuals, not offering general advice to the public. So, for example, when Dr. Oz goes on television, whether or not he's engaging in other actions that might be civilly challengeable for fraud or providing false information, he's clearly not engaged in the practice of medicine when he shares theories with the public. The second question I raised is, what should doctors be allowed to do? And there are two different kinds of behavior we want to think about: conduct related to the profession of medicine and conduct specifically related to patient care. For example, should the law prohibit doctors from advertising? This was a policy of the AMA that was adopted in many states from the 19th century until the late 20th century. It's still illegal in many nations. The concern being that patients won't be able to fully understand advertisements. They'll be led astray by doctors with more compelling advertising campaigns, and beyond that, that it was simply unprofessional and debased the profession, and that while car salesmen or insurance brokers might be able to advertise, doctors advertising transformed something that operated in a classy and professional way into something that looked like it was operating in the marketplace. Whether doctors can engage in the suspension of labor has been a historic debate as well. That's a fancy way of saying going on strike. For example, you see on the upper left, those are doctors in Canada protesting national health insurance in the late 1960s. Those are resident physicians in the United Kingdom protesting more recently. A number of countries allow doctors to go on strike. The United States generally does not. Even if patients are cared for and there's not a risk to patient care, many medical associations and state boards still view it as unethical or misconduct for doctors to strike. That is very much a cultural as well as legal phenomenon in the United States. You should ask whether it is unbecoming for doctors to go on strike the way steel workers might, or whether they are employees like everybody else and should have the same right to engage in striking. And then there are a wide range of behaviors related to patient care. And these are four examples that have gotten lots of media over the years. The first, as you may remember, if you read the case, was Griswold versus Connecticut. Should doctors be able to prescribe contraceptives or later engage in providing abortions? And the question you're not asking is just whether this should be legal or whether it's constitutionally protected, but also whether doctors specifically should be involved in the process or whether it should be a separate field outside of medicine. On the bottom right, you see a picture of Christine Jorgensen. She was not the first person to undergo gender reassignment surgery, but the first person to do so who received international attention. And the question was, and to some people still remains, whether this is part of the practice of medicine that doctors should be able to engage in gender reassignment, either for adults or then for pediatric patients as well. Greg Firth is an advocate of and man who writes about elective limb amputation. These are patients who themselves describe their condition as analogous to transgender individuals, in the same way transgender individuals use the analogy of being born in a body of the wrong gender. People who want elective limb amputation describe one of their limbs as not feeling attached to them. A Scottish surgeon, Robert Smith, was actually doing such procedures with largely positive outcomes until the National Health Service shut him down. And the patients he did operate on would not come back for more surgery, like body dysmorphic disorder patients might, but would then lie and say they were in an accident and lead normal lives, which might be preferable to letting them lie down on railroad tracks and do it themselves if we think there's a high risk. I mention only that because whether or not this is something a surgeon should be allowed to do or not raises complex questions about the boundaries of how much doctors can do for patients who have autonomy. And finally, on the upper left is a picture of Jack Kevorkian, who, for better or for worse, drew a lot of publicity to the assisted suicide or aid in dying movement, depending on your terminology, in the United States. A number of states have debated whether or not this falls under the practice of medicine. Montana, for example, even though aid in dying or assisted suicide is legal, it is in practice not available because no provider in the state will offer it because the state medical association says it's unethical and outside the scope of medical practice, and any doctor who engages in it risks being thrown out of the state medical association. So legality and professional codes may overlap, but they also may be different. And finally, at the extreme, and I will add areas I've written about for full disclosure, is whether or not doctors should be able to take part in executions and whether or not doctors should be able to take part in enhanced interrogation or torture. And that's a picture of the electric chair on the left and of Guantanamo Bay on the right. The courts have generally ruled that you need to have a psychiatrist involved in the capital punishment process to confirm the patient is sane or not impaired. And I have questioned whether or not, even if that needs to occur from a legal point of view, psychiatrists should be offering these evaluations, or whether that undermines their duty to serve the patient and do no harm. I will also mention there's been a lot of talk about hunger strikes at Guantanamo Bay, but hunger strikes occur all over the United States in the penal system, in the prisons, and they are perfectly physicians are perfectly enabled in a number of states to force feed prisoners, even those with capacity. And I have raised questions not whether that should be legal, but whether physicians should be able to engage in that practice or whether it falls outside the scope of offering forced treatment to hunger strikers with capacity. Right now, a number of states still do that. And the third big question I asked is, how are doctors different from lay people? And one key area is that we set barriers to entry, for example, medical schools, licensing requirements. We also give doctors special privileges. For example, if your patient doesn't want you to testify against them in court, they have a right to keep you from doing so. In contrast, if you share your secrets with your barber and the barber's client doesn't want the barber to testify in court, the client is out of luck. There is no barber haircutting privilege, so to speak. And then there are all the traditions that go along with medicine, white coats, black bags, the trappings that are not legally enforced but create expectations and impressions for the public. Without taking a stance on any specific issue, and I want to emphasize that I am not doing so, I do want to emphasize that there is a marketplace fallacy that people often associate with doctors. People, both in medicine and out, will say something like, well, I went to medical school, I worked really hard, I should be able to do whatever I want in my practice as long as it doesn't hurt anybody. I should be able to charge what I want, I should be able to refuse to offer certain services because I operate in the market. Now, you may have a right to offer what services you want or to charge what you want. That is a matter of public policy and debate. But I want to emphasize very strongly that doctors do not operate in the market. Doctors operate in what could generously be called a guild, though some members of this class have already begun referring to it as a cartel, in the sense that the number of doctors is artificially limited. It is limited both by the amount of money that the government will authorize for training for residents and fellows, the limits placed on access to providing care for those who are not trained through the American system, and very strict restrictions on the number of medical schools that can open, which has led to a substantially lower number of seats in medical schools than doctors would otherwise be eligible for. Meaning that there would probably be at least a third more physicians in the United States if we operated under a market, and physician salaries at a minimum would probably be a third to half lower. It might even be lower than that in a number of high-end specialties. So it's best to think of guild economics when thinking about physicians. Analogies might be to taxi medallions, where the government artificially regulates the number of people who can drive yellow cabs, or in many communities, liquor licenses, which there is a limited number of in trade. It's important to note that these are artificially constructed. As Uber and Lyft have demonstrated, or New York City has demonstrated, you could have an unlimited number of livery drivers or an unlimited number of bars, which is different, for example, from radio waves, which are limited because inherently we have to limit the number of radio waves or radio stations would interfere with each other. It is not that we couldn't have more doctors, it's we choose not to have more doctors. I want to briefly mention the concept of the physician oath, because this has played a large role both historically in determining what doctors could do, and to some degree still does so today. And you see on the screen the Oath of Hippocrates, or the Hippocratic Oath, which is the most famous, if not the most widely used, oath for physicians in the Western world. I would like to emphasize that it is primarily a guild rule rather than a conduct rule. What I mean by that is a majority of the document deals with aspects of medicine designed to protect the profession rather than patients. So, for example, the oath says, to consider dear to me as my parents him who taught me this art, to live in common with him and if necessary to share my goods with him, to look upon his children as my own brothers, to teach them this art, if they so desire, without fee or written promise, to impart to my sons and the sons of the master who taught me, and to the disciples who have enrolled themselves and agreed to the rules of the profession, but these alone, the precepts and the instruction. So basically to curtail who can learn medicine and to share and support the benefits of medicine with other doctors. And in addition, I will not cut for stone, even for patients in whom the disease is manifest. I will leave this operation to be performed by specialists in this art, which is a fancy way of saying I won't practice surgery, keeping in mind that medicine and surgery were different professions in ancient Greece and well into the modern period. Because if I do, there's a risk that surgeons will start practicing medicine and encroach on our turf. So it's as much a document about turf and the limits and boundaries of medicine as it was about protecting patients. In all fairness, there are conduct elements as well. One of them is to no one will I prescribe a deadly drug, nor give advice which may cause his death, nor will I give a woman a pessary to procure abortion. So both abortion and assisted suicide were very much not things doctors could do in ancient Greece. And then in every house where I come, I will enter only for the good of my patients, keeping myself far from all intentional ill-doing and seduction. and especially from the pleasures of love with men and with women, be they free or slaves. All that comes to my knowledge in the exercise of my profession, or outside of my profession, or in daily commerce with men, which ought not to be spread abroad, I will keep secret and never reveal. So two interesting things are there's a prohibition on having sex with patients. They're equal opportunity in that they include men and women, but also equal opportunity in a disturbing way in that they acknowledge and to some degree condone slavery by saying both slave or free. But secondly, that the confidence of doctors confidentiality rule doesn't just apply to when you're practicing medicine, as it usually does today, but applies in all of your business in the world, even when you're in a social engagement as a citizen, which is very different from our standard today. Just to show you a modern version, the Declaration of Geneva incorporates some of these elements. It includes that you will give your teachers the respect and gratitude which is their due. I like to emphasize that part. And I will maintain all the means in my power, the honor and the noble traditions of medical profession. My colleagues will be my brothers. So today there's a lot of talk about discarding some of the traditions of medicine, which we may feel hold us back or prevent equity or social justice. But as recently as the 40s, there was a pressure on maintaining those traditions. And now I want to show you briefly the Soviet Union's medical oath, which I will add was not always enforced, and to some degree the opposite. But it includes the principle, recognizing the danger which nuclear weaponry presents for mankind, to struggle tirelessly for peace and for the preservation of nuclear war. So is that the responsibility of doctors? I mean, obviously, I imagine all of us could agree that nuclear war is a bad thing. But does that mean doctors have some kind of special duty as part of their oath or their calling to work to prevent it? And you could replace nuclear winter or nuclear weaponry with climate change or human rights or racial justice. Take your pick of what social issue is important to you. At what point do doctors have this as a moral obligation, if ever? And then at what point should state medical boards incorporate this as to be part of the responsibility of doctors? I'm not endorsing that or opposing it. I'm simply saying that it's a question that guilds and medical boards have to grapple with. Now I want to shift gears, at least briefly, and talk about malpractice and the standards of care. So the four elements in malpractice that you should memorize and keep in mind as we go through the cases are: a physician to commit malpractice has to have a duty to a patient. So there has to be a specific patient you have an obligation to. You have to breach that duty in some way. And as a result of breaching that duty, you have to cause an injury to the patient. And the result has to be some kind of tangible damage. It can be physical, it can be emotional, but if the patient is not damaged in any way, they're not going to succeed in a malpractice lawsuit. So, for example, if I give you the wrong medication, but you're absolutely fine, and I figure it out a few hours later and give you the right medication, clearly an error, maybe misconduct, but not malpractice because no harm was done. The most famous case defining who a patient was is that of Hurley versus Edenfield. This is not an assigned reading, but at least the concept of the case should be familiar to you. So it took place in Indiana in 1901, and a man's wife became violently ill during pregnancy, and he sent for the local doctor, Dr. Edenfield, who had treated the family for many years in other areas, other capacities, including a previous childbirth by the wife. There was no other doctor available in the area at the time who could be procured, and Burke offered Edenfield's fee in cash, explained the situation, and begged him to come. And Edenfield, who had grown to dislike Burke over their previous sessions and previous encounters, refused to go without offering any reason. And Mr. Burke died, and Mrs. Burke died, and Mr. Burke sued. His agent's name was Hurley, hence the case's name, Hurley versus Edenfield, for malpractice. And the question was, not having an ongoing active relationship, did Dr. Edenfield, as the only doctor available, have any obligation to Mr. Burke? And I can tell you when I ask lay audiences this, most of them say this is clearly misconduct. There was a duty. If you're the only doctor available and you can save someone's life, you have to. That was not the ruling of the court. The court ruled for the doctor, and it became the standard of care in the United States going forward, or this governing principle, which is that unless you have an affirmative agreement with a particular patient, either through contract, where you actually negotiate to be their doctor, or implicitly through your conduct or behavior, you have no obligation, and therefore you can't be legally responsible for malpractice if you don't offer care. It is worth noting this is very different from hospitals, and usually doctors who work for hospitals, who under EMTALA, a federal law from the 1980s, are required to offer medical care. to anybody who shows up at their door until they're stabilized. It also differs from common carriers, like service stations and inns. So if you are driving through the desert and there's only one gas station and you have the money to pay them, they generally, historically, can't say, we don't like you, we're not going to give you gas. They have to treat all comers equally in a life-saving or emergent situation. The same was not true historically for doctors. But who exactly is your doctor? So different states have defined it differently. But just to give you an example, in New York State, it's defined very narrowly. So in Tenuto versus Letterly Labs, another case that is not assigned, a parent came forward to see whether it came forward after they had asked their child's pediatrician whether the child could get polio from a live polio vaccine, and were assured the child could not. And the child did get polio, and the child was fine. There was no damage. But the parent also got polio, and the parent sued the pediatrician. The parent said, you gave me bad advice medically, you put my life in jeopardy, I actually am injured, this is malpractice. And the pediatrician said, we were offering medical care to your kid. If you wanted medical care, you should have gone to an adult doctor. We don't offer medical advice to adults. You were just someone who happened to be in our office who we gave gratuitous advice to. If you really wanted to get care, for example, you should have paid a bill. The New York courts viewed that as a bit too clever by half, and they said that if you're a parent coming with your child to get medical advice that has implications for you, the doctor has some liability or obligation to you as well. But that is the outer boundary of care in New York. So in another case, McNulty versus New York, a woman came with her friend to the emergency room, and she was a nurse, and when the friend was diagnosed with meningitis, she asked whether or not she should get antibiotic prophylaxis to prevent her from getting meningitis as well. And the doctor in the emergency room told her no, which was wrong. And as a result of which she ended up with meningitis and impaired, and I believe she had some difficulty with one of her hands and some vision and hearing problems. And she sued, and she lost. Because the New York courts felt that had she wanted to get medical advice of her own, she should have registered in the ER, changed into a hospital robe, so to speak, and then paid a bill for her services. She was just accompanying her friend. This was gratuitous advice. There was no doctor-patient relationship. So in New York, it's very narrow. In some states, it's a very broad rule. For example, in a famous case in Tennessee, Bradshaw versus Daniel, the courts ruled that the doctors had an obligation to the wife of a patient with an infectious disease, Rocky Mountain spotted fever, even though she had not caught the disease from her husband, but rather because they'd been exposed to the same ticks that caused the disease, and they should have warned her that she might have been exposed earlier, even though she never had any direct interaction with these doctors. Very broad understanding of what a doctor-patient relationship is in Tennessee. The second question related to duty is when you can stop being someone's doctor. You may remember that one of the scenarios for the reading this week is the worst patient ever. So a patient does not have the duty to perpetual care forever. The obligation of a doctor is to inform the patient that you're terminating their care and give them a reasonable opportunity to find another provider. And in most states, that is considered to be 6 months. In the extreme case discussed in the reading, Peyton versus Weaver, Mrs. Peyton was a highly disruptive patient who refused to comport with the rules Dr. Weaver had in the dialysis clinic. And eventually Dr. Weaver got fed up and refused to offer further care. And there was no other dialysis clinic in California willing to take Mrs. Peyton because of her terrible track record as a patient. And the California Supreme Court ruled in Weaver's favor, said at some point, if the patient is disruptive enough, even if they can't find another provider, you're still obliged to provide care. You're no longer obliged to provide care. Fortunately for Ms. Peyton, she was eventually able to find a charity willing to do so. This is the slide that I encourage you to look at closely this week, because it covers the material involved in most of the cases. The question we're asking in the cases is, what are doctors expected to do? Once they have a duty to a particular patient, what conduct consists of behavior so concerning that they breach that duty in some way? Usually, breach means negligence. It means there's a standard of what doctors are expected to do, and the doctor in this particular case didn't meet that standard. Though in theory, it could also include intentional torts or intentional acts, such as carving your initials into the patient out of spite or sexually assaulting a patient. But we're going to focus today on unintentional breaches or torts. Historically, the standard was usually descriptive. The question was what other doctors in the community did, not prescriptive, what doctors should do from some ethical standard. And it used to be a local standard, meaning what other doctors in your community did. Now it's become a national standard, meaning we ask what do doctors throughout the country do. I mentioned that it's a national standard, but that means national in terms of what you're expected to know and your level of competence. Obviously, a clinic in Nome, Alaska can't be expected to have the same equipment as the Mayo Clinic or Johns Hopkins. Historically, it was usually a descriptive standard, but the case of Helling versus Cowrie that is assigned shows the rare situation where it could become a prescriptive standard. In Helling versus Cowrie, this is a case where a woman had glaucoma and there was a cheap, easy test available, and no other doctor in her community offered it, including the doctor in this case. The court found that an entire industry's custom could lag behind what was expected, meaning an entire custom of the industry could be deficient, and said that in cases where something is cheap, easy, readily available, knowledge of it should be easily accessible, there may be times when doctors have to live up to a higher standard than they're actually engaged in. Most of the time, we look at what doctors are actually doing. So the next question is, how do we figure out what doctors are doing? And historically, that required having an expert witness. Unfortunately, just like in police brutality cases, police officers often refuse to testify against one another. Doctors historically, who relied upon each other for referrals, generally refused to be experts in malpractice cases. So in Kenner versus Spence, one of the assigned cases where a young man goes in for back surgery and among other things falls off the bed because they don't put up any bed rails, he can't actually find an expert to testify on his behalf, not because his claim isn't valid, but because no doctor is willing to breach this understood convention of the profession back in 1960s Washington. And he draws a very liberal panel that basically says, through Justice Robinson, that there may be extreme cases where it's so obvious that misconduct occurred or malpractice occurred that a jury can use common sense to determine this. The other element of Canterbury versus Spence that's important is that it says that informed consent is now part of the standard of care. Now, as I mentioned in the cheat sheet for the week, informed consent is really a misnomer. It really means that the physician has to share with the patient what information a reasonable patient would want to know in order to make a decision. It's objective, it's not subjective. Whether the patient really understood doesn't matter. Because for those of you who are football fans, it's always better or easier to call the football plays on Monday morning that the quarterback got wrong on Sunday afternoon. Monday morning quarterbacking, hindsight is 20/20. In hindsight, people, if they get injured, will always say, if I really understood the risk, I wouldn't have done this. And then the question you want to ask is, does informed consent include telling people that other providers can do it better? So if I have a 50% success rate for aneurysm repair and other providers have a 90% success rate, do I have to share this? And the courts have generally said no. Why have the courts said no? There is a concern that if you had to share this information, you would have a shift of patients who could afford to go to the better providers. And you'd lead to inequity or more inequity because those who either didn't know to ask or didn't have the means of getting to better providers wouldn't be able to do so. And over time, the better facilities would get even better and the weaker facilities would get even worse. In general, a doctor cannot contract out of the standard of care, even if the patient fully understands and agrees. So if I say that usually in our hospital, a senior surgeon performs the procedure with anesthesia and a scalpel, but for you, we'll have a junior surgeon do it with a cleaver without anesthesia, but we'll only charge you half price. Even if you fully understand the risks and agree to that, you can still sue me for malpractice. Obviously, that is an extreme example, but this often comes up, for example, in complementary or non-traditional cases of prescribing, complementary medicine, alternative medicine. Obviously, if a lot of other providers do it, there's something called the respected minority doctrine, where you still fall within the scope of the standard of care, even if it's not the majority of doctors. But if you're the only person doing it, even if you have an agreement with the patient, you still may open yourself up to liability. The third element of malpractice is causation. Basically, your actions as a doctor have to be the proximate cause of the patient's injuries. So one question the law has grappled with is what happens if the doctor makes a mistake, then the patient engages in misconduct or engages in a further mistake or ignores the doctor's recommendations, and that leads to an injury. So, for example, I tell you as part of your injury not to drink or walk on ladders, and as an orthopedist, I say either of those could put you in danger, but I also set your bone poorly, and you climb up in a ladder while you're drunk and you fall off, and because I had made a mistake fixing the bone, you injure yourself again. To what degree can you recover if I'm responsible as a doctor and you're responsible as a patient for not following instructions? And there are different standards for this. I won't go into great detail, but you should know that the old standard was one of contributory negligence, which meant that if the doctor made any mistake at all, if the patient made any mistake at all, didn't follow the doctor's advice at all, they couldn't recover anything. Over time, most states have adopted either comparative negligence or modified comparative negligence. Comparative negligence means that you can recover as a patient the percent that the doctor was responsible. So if we decide that the doctor fixing the bone badly was 60% of your injury and you climbing the ladder accounted for 40% of your injury, you can recover 60% of your damage. And then some states have a modified comparative approach, which they say only if the doctor is more than 51% responsible can the patient recover anything, but then over that threshold, the patient can recover what they want, what they're entitled to. I mention that not that you should memorize this in great detail, but you should recognize the terms because they'll be mentioned in a number of the cases through the semester. And the final case from the readings for the week is that of Hawkins versus McGee. This is a case that became famous in the movie The Paper Chase in the 1970s with Jeremy Bottoms. So in this case, a pioneer in skin graft surgeon, Dr. McGee, finds a young man with an injured hand. He actually has a claw hand, so his thumb is sort of stuck to his palm. And he says, agree to have one of my surgeries and I can guarantee you a perfect hand. As a result of the surgery, the hand is far more functional. It's actually almost 100% functional. But hair grows out of the palm, which is a great deal of embarrassment to Mr. Hawkins. And apparently in the 1920s, there were associations between certain kinds of sexual misconduct or conduct and hairy palms. So Hawkins is objectively better off than he was before, but he's not nearly as well off as he was promised. And the question for the court, in the case that you will read, is whether or not Hawkins is entitled to what are called expectation damages, meaning the difference between how he ended up and what he was promised, or actual damages, meaning only the difference between how he was to start and how he was to finish, which in this case is zero because he was better off to finish. And the courts in the United States generally award expectation damages because they feel this incorporates the risk involved in the procedure and the opportunity cost, because maybe the patient wouldn't have undergone any risk at all and turned down the procedure if they didn't know they were going to get the promised outcome, or maybe they would have gone to a different surgeon who would have done it better. Another concept you should be familiar with, though you should definitely not memorize these details for New York State, is the statute of limitations. That is the principle that you can only file a lawsuit against someone, a civil lawsuit for malpractice, within a certain amount of time. And the arguments in favor of this are it ensures certainty for doctors, helps them regulate their insurance, and also over enough time, people's memories will fade. They will be encouraged to perjure themselves if they forget things, to offer false explanations to the court if they can no longer remember. One question the courts have grappled with is, does the statute of limitations start running when the injury occurs or when the patient discovers the injury? In New York State, for many, many years, the statute of limitations had started running when the patient was injured. So if you didn't realize you were injured, for example, the patient surgeon left a foreign body in you and you didn't discover it for 13 months, but the statute of limitations was a year for foreign bodies left in people, you could no longer recover. New York has changed that, but that is a complex ethical and legal question because right now, if you discover the injury many, many years later, you still may be able to sue your doctor in New York State long after they expected any lawsuits or even after they retired, which forces doctors to have insurance that covers them for their entire careers and beyond. And finally, I want to mention the concept of a Good Samaritan law. A Good Samaritan law differs from a duty to assist law, and I want you to understand the difference between the two. Duty to assist laws say that if you see a stranger in need, like someone dying on the side of the road, you have to help them. Some states have these. Most states do not. They apply to everyone, not just to doctors. In New York State, for example, there is no duty to rescue a stranger. The only exception is a half rescue. So let us say that I'm walking along one day and I see someone drowning in a pond, and I swim out to save them. And when I get there, I realize it's my boss, and I realize I don't like him. He doesn't pay me enough. So I get there, I say, sorry, I'm not going to save you, and I swim back. That you can't do in any state. Why? Because if you start rescuing, you deter other people from engaging in rescue. This actually matters for doctors in emergency situations, because once you start offering help on an airplane or in a public place, you're really obliged to keep helping until somebody else comes along or EMS comes or you've stabilized the patient. But that is not what the Good Samaritan law is, even though that's what many people mistakenly think the Good Samaritan law is. The Good Samaritan law comes from the parable in the New Testament, and it says that if you try to help a stranger with a medical need and you are negligent, you still are not going to be held liable if you're doing this for free in a public place. It applies to doctors and it applies to lay people. You can't expect payment. It can occur in the hospital setting. And you can engage in gross negligence, like mistaking the patient's choking for a seizure, or vice versa, and doing an unnecessary tracheotomy and the patient bleeds out, or amputating the wrong leg by mistake. They're extremes. But if you're simply acting with common negligence, even if you're a physician, you're not eligible for liability. And that's another concept you're going to see frequently, I think, in the cases over the course of the semester. I'm going to hold multiple sessions this week to review some of the cases, so there is no reason to panic. But I again do urge you to look at the slide governing the standard of care and also the slide dealing with Hawkins versus McGee. And if you understand those two slides, you really have the heart of the material for this week.